On April the 9th of the last year, Prince Philip, Duke of Edinburgh, who had served as the nation's longest-serving consort, passed away at the age of 99, 2 months before he would have reached 100. After they had tied the knot in 1947, he had been happily married to Queen Elizabeth for 73 years. Now, media reports the Queen is currently awaiting a major ruling following her heartbroken attempt to ban Philip's will from the public domain. After the passing of a senior member of the royal family, it has been customary for over a century that an application to have their will kept secret is submitted to the President of the Family Division of the High Court. This has been the case regardless of whether or not the will was sealed. As a consequence of this, the will of senior members of the royal family are not subject to the scrutiny of the general public in the same way that a will typically is. But The Guardian has launched a challenge against the decision to hold a hearing on an application to seal the will in private. The appeal hearing is not a challenge to the decision to seal the will. During a private hearing held in July of last year, the current president, Andrew McFarlane, listened to the legal argument that was presented by attorneys who represented Philip's estate, as well as the Attorney General, who represents the public interest in such matters. It was decided that the will ought to be kept secret from the general public for a period of 90 years. As President of the Family Division of the High Court, Sir Andrew is the curator of a safe that contains 30 envelopes. Each envelope contains the will of a member of the royal family who has passed away, and all of the envelopes are sealed. The decision to hold that hearing behind closed doors is being challenged right now by The Guardian, which is contending that the decision was disappropriate and unjustified. In documents submitted to the Court of Appeal earlier this year, attorneys for The Guardian argued the judge in the High Court erred in law by denying the media an opportunity to make representation regarding whether the hearing of the application to seal up the will should go ahead in private, with no representatives of the press being allowed to attend. This was in response to the judge's decision to deny the media an opportunity to make representations regarding whether the hearing should go ahead in private or not. In January, the Court of Appeal allowed The Guardian to appeal against granting permission to do so. There is no legal recourse available to contest the choice to bury the will. The attorneys for the newspaper said the High Court made a mistake by not considering any lesser interference with open justice than a private hearing from which accredited members of the press should be excluded. The lawyers said, as a result, the decision to hear the application to seal up the will in private was disappropriate and unjustified. They stated that there was a strong public interest in transparency, and that it was wrong of the executor of Philip's estate to argue that the media's interest in the hearing was prurient curiosity, adding, "These are fundamental matters of public interest concerning the royal family, members and the sovereign in a constitutional monarchy." Although the legal dispute over Philip's will continues, there have been several shared royal wills in the past, including Princess Diana's. The tragic death of Princess Diana occurred as a result of an automobile accident that occurred in the Pont de l'Arme tunnel in Paris when she was only 36 years old. Not everyone of her young age would have thought to have penned a will, but, having come from an aristocratic family and once being married to the heir apparent to the British throne, the mother of two had put into writing how she wanted her wealth to be distributed once she passed. The will that Diana left behind was quite generous. Not only did she provide for the financial well-being of both of her kids, Prince William and Harry, but she also provided for her godchildren and favourite staff members. According to the appendix that was included with the former Princess of Wales's will, the total value of her estate amounted to more than £21 million when she passed away in the year 1997. The money came from the settlement that Diana reached with Prince Charles over their divorce, as well as shares, jewellery, cash and other personal valuables that were taken from the family's Kensington Palace home. According to the reports, the deceased woman's heirs were left with around £13 million after the payment of inheritance taxes, which represented a sizable portion of the total amount that had been indicated. William and Harry were the main beneficiaries after being left without their mother, but the princes were not the only people to be handed sums of money. Paul Burrell, Diana's loyal butler, was left a bequest of £50,000 in her estate. According to Worthy.com, her 17 godchildren were also identified as beneficiaries of her estate, and she reportedly gave them a variety of valuables, including sentimental photographs, paintings and china. A discretionary fund outlined benefits for the princes, their future spouses and family members, and special charities received £100,000 plus Princess Diana's wardrobe, including her famed wedding dress. Certain charities were permitted to benefit from royalties brought in from continued authorised commercial use of her intellectual property. What was left of the estate, once the above had been dished out, was to be divided between Diana's two sons, William and Harry, who were 15 and 12 respectively when she died. Reports have speculated that their mother left them a fortune of £13 million, which reduced to £8.5 million after death duties. Years of clever investment by royal advisers meant the fortune swelled to more than £20 million by the time it came back to the siblings. Diana's will stated that her sons should receive some of their inheritance at 25, then the rest of the money when they turned 30. Both brothers paid inheritance tax when they received their shares of the fortune. Prince Harry, in the tell-all interview with Oprah Winfrey that he and Meghan Markle conducted last year, said the couple survived on the inheritance after quitting as senior royals in 2020. He told Oprah, "I have what my mum left me, and without that we wouldn't have been able to do this. It's like she saw it coming, and she's been with us through this whole process." For the Queen Mother's will, the Queen Mother put a significant portion of her wealth into a trust fund, which was designed to be distributed equally to all of her great-grandchildren. However, she reportedly stipulated that Prince Harry would receive a larger share than Prince William. Therefore, when she passed away at the age of 101, the brothers were left with £14 million to divide between them. However, it was previously arranged that the younger brother would benefit more from the agreement. The logic behind the Queen Mother's decision is based on how finances within the royal family work. When the Queen passes away and Prince Charles ascends to the throne, it seems expected that William will succeed Charles as the Prince of Wales. This indicates that he will receive the Duchy of Cornwall as an inheritance. The Duchy of Cornwall is a private estate that supports the public, philanthropic and private endeavours of the heir to the throne. On the other hand, Harry will not receive any of it at all. After the passing of the Queen Mother, Buckingham Palace made public certain aspects of her will, despite having previously petitioned the High Court in an effort to keep it secret. Her estate, which at the time was estimated to be worth between £50 million and £70 million, was left to her daughter the Queen. The Queen donated a significant portion of her personal art collection to the Royal Collection, which is now housed in Buckingham Palace and can be viewed by the public. During that time, a statement that read as follows was issued. The Queen has been left the entirety of Queen Elizabeth, the Queen Mother's inheritance, which mostly consists of the belongings that were found in her several residences. She requested in her will that the Queen leave specific bequests to members of her staff, and she also stipulated that these bequests should be subject to inheritance tax in the standard manner. The Queen has decided that the most important of Queen Elizabeth's pictures and works of art should be transferred to the Royal Collection.